Hi, my name is Aslam Moolla and I am a registered attorney. In today's video, I'm going to be sharing with you the procedure for disciplinary hearings in South Africa. In particular, how does the process work? You might be going through a disciplinary hearing and you might not know what the process is. Then this video is for you. So let's get started with it. Usually, you will arrive at the company premises on the day of the disciplinary hearing. However, in recent times, we've been noticing a trend that disciplinary hearings also take place virtually. In other words, you will be provided with a link either to Teams, Zoom, or Google Meets where you will have a virtual disciplinary hearing. Step 2, after arriving, you will enter the room where the disciplinary hearing is taking place. Usually then, in this particular step, the chairperson will introduce himself and all of the parties that are present. It's very important to note at this stage that company witnesses or your witnesses cannot be seated in the hearing at this particular point. The reason why is they can only be involved in the hearing when it is their time to testify. If it is not their time to testify, especially at the beginning stage of the hearing, you should politely ask the chairperson to exclude them from the hearing room. The reason why this is important is also for confidentiality purposes. No other persons should be in the disciplinary hearing room unless they are directly involved in the case. After the chairperson has introduced everyone, the chairperson will then read out your rights in terms of the disciplinary hearing. Also, he or she will read out the charges against you. At this point, you have an opportunity to either plead guilty or not guilty to the charges. If you plead guilty, the case goes straight to the sanction stage. In other words, no real evidence is led because you've already pleaded guilty. If you plead not guilty, then the company starts with their evidence. After the company starts with their evidence, you will get an opportunity to lead your evidence on each of the charges. After both sides have led their evidence, the case then goes to closing arguments stage. We've done a separate video on our channel regarding what is closing arguments, the different types of closing arguments, and how to prepare closing arguments. Once closing arguments are submitted from both sides, the case then awaits a ruling from the chairperson. In other words, the chairperson should be a fair, neutral, independent person that then applies their mind to both sides of the case and comes to a written ruling confirming their recommendation whether you should be dismissed or you should be given a final warning or any other form of sanction. It's very important to note that the chairperson must provide reasons as to why that particular sanction should be imposed. In other words, if you are found guilty of the charge, the chairperson can't simply say, guilty, I recommend dismissal. The chairperson must say, I recommend this person should be found guilty and here are the reasons why, and therefore I recommend the sanction of dismissal. In summary, a disciplinary hearing process is meant to be a fair, impartial, independent process where both parties have an equal opportunity to lead their case. In practice, however, because employees do not have the necessary skills and experience, they often suffer because they just don't know what to do and how to do it. The best way to combat this is to make sure that you prepare as much as possible so that you can put your best foot forward. If you need help in your situation, you're more than welcome to click the link below and book an appointment with our office. I wish you all the best and I'll speak to you soon.